Welcome back to Good Law, Bad Law. As we are in the middle of the public hearings on the impeachment inquiry in Washington, it seemed appropriate to have as a guest on the program someone who knows an awful lot about asking good questions. My guest today, Shanin Specter, a founding member of the prominent law firm here in Philadelphia, Kline and Specter. He also happens to have been my boss way back in the day, and a friend and a nationally renowned trial lawyer. As well as someone who has taught this very subject, how to ask a question, in law schools all over the Bay Area, Hastings, Berkeley, and Stanford, and also at Penn. And of course, he continues to be a trial lawyer and try many cases in court. Shanin and I talk about how to ask a good question and some of the ways in which it's important to think about all the non-speaking ways that are related to the asking of good questions. And we relate this to what's happening in Washington and our hopes for good question asking during these impeachment hearings. So stay tuned for a great conversation. Lots of questions and lots of answers with Shanin Specter. Stay tuned. This week in Washington, we begin impeachment hearings in public in the U.S. Congress. Many Americans are going to be tuning in, many for the first time, and listening as investigators question witnesses involved in the Ukraine scandal, the Ukraine affair. So it seemed appropriate this week to talk about how you ask a question, and my guest is somebody who knows a lot about asking good questions. Shanin Specter, founding partner of the law firm of Kline and Specter here in Philadelphia, my former mentor and boss and friend. Shanin, thank you so much for being here.
Aaron, thank you so much for being with me and to give this topic an important airing.
It is important, and I know that your lifetime of experience in the art of asking a question primarily has been in the courtroom and in the proceedings that lead to trial, deposition taking, and things like that. So as a lawyer, but you also teach law students, and you've had a public speaking career as well at times when it's fit into one of your cases. But the idea of how to ask a question is important for non-lawyers as well, and how to listen to a good question and how to get an answer to your question. So this is a great topic, not only for the lawyers in our audience. So give us an introduction to the idea of what is a question and what is a good question.
Yeah. Well, Aaron, that starts off with your question to me just now. And your question was a good question.
Well, it had a long intro, so I don't know if that makes it so good.
No, but when you got to the question, it was a good question. It was a good question because it was expressed briefly. Yeah. You used few words. It was clear to the listeners what you were asking, and it could be answered briefly. So I congratulate you. You're also a great questioner. You run a fantastic law firm in Philadelphia, and you're a great lawyer. And so this is something where I could ask you the questions about how to be a great questioner, and you could do at least as well as I could do in answering those questions. I would first comment to you that you're right, that knowing how to ask a good question is important whether you're a lawyer or not. And think about walking into a Starbucks and trying to order a cup of coffee. And let's say you are caffeine intolerant, as I am. And
I'm sorry.
And yes, thank you. It's an underappreciated handicap, yes. Really. And think about for a moment, how do you be sure that you have received a cup of coffee that is without caffeine? So a lot of folks might say to the person who hands them the cup of coffee, is this decaf?
Yes.
And the problem with that is that that question is likely to result in an incorrect answer, because that's a leading question. Mm. And it's a leading question asked to someone who is busy, who is incentivized to give the shortest answer possible to get the customer to move along, without reference to whether the answer is correct. So the correct question is not, is this decaf? The correct question is this regular or decaf? You can't put the answer in the mouth of the answerer in that situation. And if we take that forward into a deposition or a trial setting, it's very useful to think about things in those terms. Who am I asking the questions to? Who's listening to the answers? What sort of information am I trying to obtain and am I trying to convey? And I teach law students about this. I've taught a course called How to Ask a Question at 4 American law schools, what used to be called Penn Law School.
As of this morning.
Now called Carey Law at the University of Pennsylvania. I've taught this class at Hastings, at Berkeley, and at Stanford. I'll be teaching it again at Stanford Law School in January. And so if I may kind of lay out what I think is the right way to approach asking a question. So the first thing to do is to learn the subject matter about which you're going to be asking. If you're a lawyer and you're going to be asking questions at trial or in deposition, you have to read the relevant documents and learn the field in which you're asking the question. It makes no sense to start asking unless you know what it is you're asking about. And it's important not to let yourself be in a situation where you have forced yourself to ask questions of someone where you don't know what there is to know about what they know, at least to the degree you possibly can. And sometimes, of course, you can't know. If you're handling a criminal matter, you've got a preliminary hearing, you may not know what the witness has to say, and you may be stuck. Or in some kinds of proceedings, in some places, there's no what's called discovery, and so you don't really know what's going on in the past. But in the circumstances where you do know, you have to master that information. And then you have to formulate your questions, keeping in mind what's important to the circumstance that you're in. If you're a lawyer and you're going to be trying a case, you have to think about what are the elements of your proof if you're a plaintiff's lawyer, or if you're a prosecutor, what are the elements of the proof of your case? And if you're a defense lawyer, either criminal or civil, what are your affirmative defenses and what are the elements of those defenses? And then formulate your questions with all of that in mind. And then you need to ask a single short question using short words and old words, not new words, and words that are very familiar to the fact finder. And when you have asked your question, you then have to listen carefully for the answer. And if you do not get an answer that is responsive, you need to ask the question again. And it's useful to ask the question in exactly the same words,
right,
and exactly the same tone, because the fact finder hears you do that, and they think well of you for not getting angry and not changing the question.
Well, let me focus in on that example, because that's a great example where you've asked a question, you've listened to the answer, you appreciate that the person you've asked the question of didn't answer the question, and you re-ask the same question. I understand your point about needing to be familiar, even to master the subject matter that you're going to be asking about. But don't you have to also be mindful of who you're asking the question to? Because, or if not who you're asking the question to, who you want to hear the question. So if you're in court, I think obviously my main focus is the jury. Even more important than the witness is that how is the jury hearing my question? How are they hearing the answer? But if I'm talking to that Starbucks barista, I'm thinking about my question differently in that situation. You pointed out there's someone busy, they may not be paying full attention, or another non-lawyer example that I was thinking about as you were talking about Starbucks. I have a stepson who's got severe food allergies. We face this all the time when we go out to a restaurant, and we want to make sure that the kitchen is equipped to deal with food allergies, and have been in situations where we'll ask the server, my stepson has allergies to dairy. Is that something, your kitchen can handle? And we've seen sometimes where the answer back is, okay, so no milk, but you can have cheese on the burger? No, this is all dairy, not just in liquid form. So it does obviously matter a lot who you're speaking to when you ask the question. But I can, again, to come back to your example, I can see different situations where how you ask that initial question and then how you ask the question again can matter differently depending on who you're talking to. Like, I wouldn't want to do that with my wife if I'm in a conversation with her, for example. She would tell me, "Oh, I'm lawyering her," and she'd be right. But in court, for sure, often it can be very effective to just re-ask the same question, because really you're saying more than just the words of the question when you do that.
That's a very good point. When you use the same tone and ask the question with the same words, you'll have some jurors who will pick up on the fact that you're asking exactly the same question because it wasn't answered the first time. Right. And they won't resent you for it because you're asking it in a reasonably nice way. Right. And you use the same words. And then if the question is not answered responsibly for a second time, which is common, then the jurors will start to get annoyed, not at you, but at the person to whom you're asking the question. And if it's an opposing party, it will help your case. Even if it's a neutral witness, it may help your case. And then I would urge you then to ask the question a third time with the same words and the same tone.
And this brings another point about questions, which is sometimes you can ask a question without saying a word. I've seen your partner, who was also my mentor, Tom Kline, do this many times, where he would ask the question a second time and not get an answer, and then he'll do one of those sideways looks over towards the jury as to say, "You heard that, right?" But he doesn't say that. Yes. But he says it with his face.
Yeah, Tom's a little bit more emotive than I might be in that situation, but it's been very effective for him and very convincing.
Right.
But then when you get an answer eventually, and when you get an answer, the answer may be different than what you thought, and it may spark in your mind a series of additional questions that you hadn't really prepared to ask. Yet you have on your yellow pad your next question, which is going in a different direction. And then the question is, what do you do? Do you ask the questions that are triggered by the answer, or do you ask the next question on your pad? Mm-hmm. And I urge listeners to choose the former course and let the answer given by the person to whom you're asking the question guide your next question. And so imagine it somewhat like the trunk of a tree, and you're going up a main branch with your question. And then the answer suggests a subsidiary set of questions, like a subsidiary branch. And you go up that subsidiary branch with your additional questions. And you may even find that the next answer after that suggests even a further set of subsidiary questions. Right. And go ahead up that additional smaller and smaller branch, and then work your way down to the somewhat larger branch, maybe back up to another subsidiary branch, and eventually back down to the main branch and the trunk of the tree, always keeping in mind that you have to focus on what you're being told and how that's provoking additional questions, and not necessarily what's next on your list of questions.
Now, that makes so much sense to me, and I think that I do that instinctively, but hearing you say that, why? I mean, why is that better?
Well, it's better for a number of reasons. First, because the listener is assisted by it. The listener wants that. If your question and answer has sparked something in your mind, it's probably sparked something in your listener's mind. So they want the answers to those questions too right now. They don't want to wait. That's number one. Number two, when a witness gives an answer that may seem unresponsive, that's often a defense mechanism where they have said something that perhaps they didn't mean to say, or which is a tell about a sensitive area for them in defending their own position. So you want to get right after that. And then a further point is that if you don't tackle those newly formed questions now, you're likely to forget them because they're not on your pad.
That's right.
So go ahead and ask those questions now. And it's tricky to keep in mind what additional questions are being flagged by the answers that are being given. You may need to take notes as you go, or for those of us who are lawyers, in deposition or a trial, you can have what's called real time on a screen in front of you where you can see exactly what questions you're asking and what the answers are, and they can help jog in your own mind what your next questions ought to be. In everyday life in the restaurant with a child that is lactate intolerant or glucose intolerant or whatever the problems might be, and I had the same issues in my house, only it's with my wife and not a child. that can be a little more complicated because you don't have a pad in front of you, and it's hard sometimes to remember exactly where the conversation is going. I find myself, I'm not sure about you, but I find myself trying to let others ask their own questions and trying not to break in to the conversation to be of assistance. But then I find myself sometimes trying to clean up what I think is a failure of communication between, let's say, my wife and a server, where I'm concerned that the server just does not know where the conversation is. And I would guess you find yourself in the same position. And that's delicate, isn't it? Because you don't want people to be upset with you, and you're an excellent lawyer. And so it's very hard for you to mask how good you are at your craft. And you commented about this earlier, that you're concerned that people are going to be resentful of you for whatever it is you say. So this is a very delicate situation, and you have to, at least outside of a courtroom, back off to some degree the power of your own intellect.
Well, yeah, especially in non-professional settings. I mean, I would try hard, and sometimes not successfully, but I try hard not to sound too much like a lawyer when I'm talking to one of my children or to my wife, or, in some non-lawyer setting. But in a courtroom or in a deposition, the skills that we learn about how to ask a question obviously are hugely important and matter so much. So, I mean, one thing I'm wondering about, since we're talking about how you ask, and how you ask is the words. You talked about short words and old words and simple declarative sentences. In the form of a question, of course. But tone of voice is also important. And we were talking about your partner briefly earlier. And obviously lawyers have different styles in public speaking and in courtrooms. You and Tom are very different stylistically. I have my own manner in the courtroom that's different from other people who work with me. I think people have the impression that to ask a good question, you have to be very aggressive, but maybe because that's what so many people have seen on TV going back to, Perry Mason days. But how do you feel about that? Because I think your style is much more direct, and you to a large extent, let the question speak for itself almost.
I'm worried if I am aggressive and get an answer that's favorable to my case, that the jurors will think that the answer was given not because it's the truth, but because the witness just wants to agree to get out of the courtroom or to get to the next question or just to get off the witness stand. That's of no help to my case. So I find that it's useful to keep the tone very businesslike, to not raise my voice. I find it to be useful to not ask leading questions, because when I ask a leading question, then I get the answer that the question suggests, which of course is the definition of a leading question, a question that suggests an answer. I'm concerned that the jury thinks that the suggested answer was given, again, because the witness was led to it by my question, not that they really mean it. For example, imagine a red light, green light case. And if I were to say to the opposing party, the light was red when your car entered the intersection, wasn't it? And the opposing party says, oh, yes. Why did they say yes?
Yeah.
Did they say yes because they meant it? Or did they say yes because I bullied them into the answer? And what does the jury now think? The jury now feels sorry for the opposing party. They don't like me, and therefore they don't like my client. The light might have really been red for the witness, but the jurors are prepared to look kindly upon the witness. Whereas if I ask the question, what color was the light when your car entered the intersection? That's a non-leading question. It's asked in a nice way. If the witness party answers saying red, then I've gotten the answer that I came for, and the jurors will believe correctly that that is the truth. Now, some people labor under the misconception that you shouldn't ask a question to which you don't know the answer. And that's not quite right.
Yeah.
You just shouldn't ask a question whose answer can hurt you. In that situation, I wouldn't ask an opposing party what color the light was in any form, aggressive, non-aggressive, leading, non-leading, unless that party were on the record giving an answer that's favorable to my client, either a police statement or a statement in deposition or otherwise, so that I have something to what's called impeach them with. Again, in a very nice way, if they give an answer other than red. If they say, I don't know, or I think yellow or green, I can then take the previous statement and show it to them and ask them if that was what they said and if that's correct. So the real trick there is don't ask a question whose answer can hurt you. And that answer, yellow, green, red, I don't know, it doesn't matter what the witness says as long as I have backup for the proposition that the light was red.
Well, the other rule that you're suggesting is shouldn't necessarily be the rule, is the idea of not asking a leading question, which I think is just widely accepted wisdom about being a trial lawyer, that's one of the most powerful tools a lawyer has, that cross-examination is, I forget which famous justice said this, you may remember, but it is the disinfectant that, cleans up the stain or something like that. But the power of cross-examination and the art of asking not only a good question, but a good leading question that can be so effective in a trial examination. You're saying, and obviously going against the grain of that rule has done very well for you, but you're saying something that does go against a fairly widely held common belief about good trial practice.
Well, candidly, I find myself asking leading questions in court. I don't do it for any reason other than control. If the questions are leading, they call for a yes or no answer, and you can control the pace of the examination by asking leading questions, whereas non-leading questions provide somewhat more room for the respondent to answer with something other than a one-word answer. So I confess that I do sometimes, even often, ask questions in a leading form. But I think for the really important questions, the ones that make or break the case, it's much better to ask them in a non-leading way. Back to your quotation, I think you might be thinking about Professor George Fisher of the Stanford Law School, a great evidence professor, who said that cross-examination is the jury's lie detector. And that's a great concept, because in a courtroom, especially with a good lawyer, a good questioner, she will be able to extract from the witness, highly likely, something close to the truth by polite but persistent questioning.
And again, it doesn't have to be with your arms waving and your voice raised. It really is, I think you're right, about persistence. And you can't be persistent if you're not listening. And so I think the point you made about listening to the answers is so hugely important. How can you ask the follow-up that pins down the witness? How can you ask the follow-up that gets at the next point of fact that the witness hasn't yet testified to unless you've listened to the answer?
Yeah. So one example of questioning that felt to be highly unsatisfactory was the questioning of Robert Mueller in July of 2019, where he came before Congress to talk about his report, and you had questioning from members of Congress that was limited to 5 minutes apiece. They alternated between sides, so the Republicans would ask for 5 minutes, the Democrats for 5 minutes. That was no time to develop a line of questioning. It was difficult further because members tended to ask questions off of a sheet, paying no attention to what was the answer that was given, just going to the next question. And
they probably didn't write their own questions. Probably a staff person wrote the questions for them.
And that's too bad also, isn't it? And there were very few questioners who were good. You commented at the start of your program about the impeachment hearings starting on Wednesday. And we're going to see, aren't we, what's going to happen. I very much hope, that the questioning is done by experienced questioners. There are a few members of Congress on both sides, keyword there is few, who are experienced questioners. If they're going to permit members of Congress to ask the questions, it ought to be limited to those members who are experienced questioners. Alternatively, the questions could be asked by staff attorneys, that they would do a fine job as well, so long as they're experienced. And the segments should not be limited to 5 minutes, and I would suggest rather they should be an hour in length, alternating sides. That's exactly the procedure that was employed by the House Intelligence Committee to date in the so-called private hearings that they've had. They have had the questions asked by staff, not by members, and they've been an hour per side.
Exactly.
And that's the way to develop a real ability to get at the truth.
Yeah, I think most people don't appreciate that there is not only nothing wrong with the way they've done things to date, but it's necessary. In the same way, no prosecutor would prosecute a crime without first having done an investigation. You wouldn't want to hold public hearings without having conducted what I view as depositions, the same as we do in any case before trial. But even the media still has to refer to them as closed door, testimony. Of course it's closed door. You're not going to leave the door open.
Well, we have the same thing, don't we, in civil litigation across the country. You're a great civil lawyer, and when you take what's called discovery in a civil case, you're doing it by way of deposition, which is the same thing, questioning under oath, and you do it in your conference room, and it's well held that that's not a public event. The public is not invited to attend, not permitted to attend unless all the parties agree. Right. And that's the way you get at the truth. And one thing that I know you know, Aaron, and that I teach my students is that there are no dumb questions in a deposition because you're trying to figure out what happened. The only dumb question in deposition is when you've gotten a concession from your opponent or from a fact witness, and you ask the question all over again because you're so excited by the answer that you got that you feel the need to ask a question again. And then the witness figures out that they gave a bad answer to start with, and then they change their answer. Now you've got a mess of a transcript.
That's right. Okay, so, and I want to come back to these impeachment hearings that we're going to be watching with great interest in a couple of days. But I'm curious about something else that relates to the asking of a good question, or the good asking of a question, that I think a lot of people don't think about, which is the time between the answer and the next question. And this, I think a lot depends on the witness, but you do develop a feel pretty early on what kind of witness you have. Are they giving short, clipped answers, or are they giving long-winded answers far beyond the question you asked? And sometimes the pause is also a means of control, because you may let the answer hang in the air just for a pause. You may let a beat go by. Maybe the witness is feeling nervous and they want to fill that space, and something good can come out that perhaps you didn't even think about, both in what the witness says and how the witness appears. I mean, do you find that can be an effective part of question asking? I
think that your points are excellent, and yes, I definitely agree that there are times that you want the the damaging answer to linger in the air and to gather strength and ballast just by laying there. And sometimes you just want to stand in the middle of the room completely motionless and let the jury see you motionless, so they understand that this is like a moment of silence, and we're going to absorb what we've just heard. On the other hand, there are times that you want no time to linger between questions, and I'll give you an example of that. So imagine that there has been a very effective examination by your opponent, which has ended on a high mark. And of course, one thing that I teach my students is to start strong and end strong. So you want to end with a very strong question and answer, which seems to be very damaging to your opponent's case. So the thing to do if you're on the other side of that case and your opponent has just asked a question and got an answer that's bad for your case, and then they say no further questions, and now it's your turn. You need to jump right up and ask your first terrific question, to which you know darn well you're going to get a very helpful answer right away. And then you get that very helpful answer. And that takes so much of the steam out of what's just happened with your opponent and the answer that they've obtained. And it takes the steam out in two ways. One, because now the question answer has been matched by what you've done. But perhaps more importantly, There was no time at all for the jury, the fact finder, to linger on the previous question and answer. And they see that you weren't fazed by it, that you don't care what just happened. You're not paying any attention to what just happened. You're jumping up and you're getting your terrific testimony adduced. A corollary to that is what's happening when your opponent is destroying your witness. What should it look like?
That never happens.
Well, yeah. Unfortunately, we don't control our witnesses
Right.
or the facts of our cases.
Yes.
And sometimes your opponent is doing a great job of eviscerating a witness that you called, and what they're doing on a cross-examination. And the question is, what should you look like when that's happening? So there was a great trial lawyer in Philadelphia who practiced between the 1920s and the 1970s named Morton Witkin. And Morton Witkin famously said, "Never let your face show how hard your ass is getting kicked." So no matter what happened,
That's right.
no matter what happened in the courtroom, he was blasé about everything.
Yes.
And then the next generation of lawyers, led, I think, by James E. Beasley, who practiced between the 1950s and the early 2000s, had a technique when his witness was being eviscerated, and that is that he would take a pencil from off of his desk that was recently sharpened. So he would then try to balance the pencil on its pencil point. Well, as you know, you can't balance a sharpened pencil on its point. That's not physically possible, but you can try. And I would see him do that, and I would look at the jurors, and some of the jurors would be looking at the witness, but some of the jurors would be looking at Jim Beasley trying to balance the pencil, and they'll also be seeing that Jim Beasley wasn't taking any notes. He didn't seem concerned, and it seems to take some of the steam out of the examination that the other lawyer is goofing off at his desk, and that's what Jim Beasley would do, and did it very effectively.
That's such a great point, and that is the theater of the courtroom. That if you can have the jury paying attention to you even when you're doing nothing, that means they're not paying attention to the other guy.
I wonder how you handle something, if you don't mind, Aaron. So in a case where your opponent is playing a videotape, and you know what the videotape is going to show because you've already been through the transcript, do you ever get up and walk out of the courtroom and come back at some point in time when it's almost over?
I don't know that I've ever gotten up and left the courtroom, but I've stopped paying attention.
Yeah.
And of course, there's the old trick that I know we've all done at the end of a cross-examination of a particularly difficult witness, which is you ask some, very dramatic question that is all about the question and not the answer. And then you very dramatically sit down before the witness can even answer, as if to say, I don't even really care what you're going to say.
Or you say withdrawn, right?
Right. You get an objection.
You don't even allow the question to be answered.
Right.
Well, I've taken to leaving the courtroom during those videotapes. I leave somebody in the courtroom just in case something goofy happens, which you can imagine the kinds of things that could happen in a courtroom with a jury sitting in the box. But I take the viewpoint that I want the jury to see that I'm not there. And I want them to see that I care so little about the videotape that I am not even bothering to be in the courtroom. Yeah. I concede that it has a slight potential to backfire because the jurors may feel, how come you're not here? Yeah. But I think overall it's a good technique, particularly if you have another lawyer who's sitting at counsel table and for all the jurors know, you're in the bathroom. Right. I mean, it's a long bathroom break. Or you're, making it an important phone call or God knows what. Anyway, I leave.
I don't know that I would recommend that for a junior trial lawyer.
No.
I mean, I think there are certain things necessarily that those of us who have gray hair at this point can get away with in the courtroom that perhaps a young lawyer has to earn the right to make that kind of a move. But I think that can be I think it is important to show something of your own take on what's happening, though you don't want to show too much emotion, and certainly not if something's going bad for you. But we've talked about a variety of ways that we communicate to a jury or to the listening audience or the fact finder through words and gesture and all kinds of ways, through the pause. So, which brings me back to how we started, which is these important hearings that are going to be aired publicly. And one of the concerns that's been raised, in addition to the one you pointed out, which is how effective will the questioners be, is how closely will people be paying attention? This is an enormously complicated fact pattern already. I mean, we're talking about a faraway land and, even things like quid pro quo. I think people have learned more about quid pro quo than they want to know. But obviously, this is a very political process, too. So if the American people don't come along with the evidence the Democrats are going to lay out, this is going to go nowhere. Conversely, if the witness is presented in a way that the public comes to show great support for this, that's going to put pressure on the Republicans in the Senate. So obviously, now we have a huge audience we have to care about in terms of how questions get asked. How do you see this problem, and what do you think is important in either side or both sides in terms of how they ask questions and how important it is the way they ask the questions?
Such a great question, and it raises the more fundamental issue of whether this case, the impeachment case, is being tried to an impartial jury.
Yes.
In the Senate Watergate context, when the Senate Watergate hearing started, most Americans were against impeachment, and it was only through the questioning and the answering, done again by staff counsel for the most part, of compelling witnesses, including White House employees like John Dean, who was White House counsel, that the opinion of the American public shifted from against impeachment to in favor of impeachment. That was over the course of many months. But in 1973 and 1974, the American public was not as sharply divided along partisan lines as it is today. Mm-hmm. It seems like everybody has chosen which tribe they're in.
Yeah.
And are they red or are they blue? And if they're red, it seems that 95% favor the president no matter what happens. He has famously said that he could shoot somebody on Fifth Avenue and nobody would care. People thought he was joking when he said it, but
until his lawyers made that argument in court the other week.
Yeah, I mean, few of us think that it's really a joke, and at this point, and so I wonder whether the American public is prepared to be impartial, to have an open mind. I mean, it's one thing to say I have an opinion, but I'm willing to listen and I'm willing to be convinced. It's been famously said that Lee Harvey Oswald could have gotten a fair trial in Dallas because the question would have been, could 12 people have an open mind as to his guilt? And the conventional wisdom is that he could have gotten a fair trial in Dallas in 1964. But I'm not sure that the proponents of impeachment or the opposition to impeachment can get a fair trial in the sense that it seems as if the jury, which is the American public, as well as the members of the House and of the Senate, have made up their mind.
Well, and we may be getting too deep into the weeds of impeachment here, but I'm trying to apply some of what we've talked about the different considerations and how you ask questions in a courtroom to now a different kind of courtroom and a different kind of jury. I think you're right that Democrats and Republicans on the two polls are already decided. Largely, but you do have independents in the middle. So let's assume there is some slice in the middle that we call independents who could go either way. The role of independents is as voters in the 2020 election, not just presidential, but I think importantly in the upcoming Senate elections, we saw suburban voters who might approximate something like independent voters carrying a lot of sway in Virginia, in Pennsylvania, in Kentucky. If you know that if that's the slice that really is going to make or break the outcome here, and you're a Democrat asking questions during these public hearings, I mean, it's not going to do you any good to ask the table thumping, arm-waving question that appeals to those already in support of impeachment, maybe someone who was in favor of impeachment the day after the election. Can you think of how that would guide the way you have to ask questions and conduct your examination during these public hearings, if that really is the relevant, decisive audience in this?
the answer is yes, but I'd have the same guide if I were a Democrat or a Republican asking questions. If I were a Republican asking questions, and in my heart I wanted the president to prevail, the way I would ask the questions would be in a non-leading, brief manner, using short words, not long words, using old words, not new words.
Right.
And I would let the progress of my questions and the witnesses' answers guide the outcome. And I would not try to put my thumb on the scale in an obvious way, because the fact finders will see that.
Yes.
And that would be my guide, whether I were a Republican or a Democrat. And I would hope that my case would be strong enough that I would be able to win the case on the merits by asking questions in that way. After all, the exploration is not about the questioner, the exploration is about the answerer. We lawyers can only ask. It's the witnesses who answer, and the witnesses have greater power than the questioners. I've said to my students that as between a great questioner and a great answerer, the answerer will win. Why? Because he's answering. And the same thing's true with a mediocre questioner and a mediocre answerer. Who will win? The answerer, because the answerer is answering. The questioner can only ask.
That's right.
And what I'm hoping for here, I'm not holding out much optimism. What I'm hoping for here is that the witnesses themselves will be sufficiently powerful by virtue of their background, training, and experience, and by the freshness of their memory, and by their dispassionate nature, their even reticence to be talking about these matters, but their allegiance to truth and patriotism, that Americans will be moved one way or the other. Mm-hmm. That's the wonderful thing about the fact that most of these witnesses are from the Department of State.
Yeah.
They're career diplomats. They are, by the nature of their training and their experience and their background, they're not partisan people. Many of them are not registered with a political party. They are career Foreign Service officers. Some of them are career military, again, who are not only by tradition, but also even by law, are required to stay out of politics. So it's my hope that they will show that measure of detachment and adherence to the truth, and not to an agenda that will move that 5 to 10% of Americans who might be the key number. You call them independents. I think that they are largely independents, although some of them are probably registered with one or the other political party, but they think of themselves as being independent-minded. I mean, I know I do.
Yeah.
I'm in a party, but I don't regard myself as associated philosophically with a party. And I hope that can happen, but I have my doubts.
Well, that gets to something that we would have to have a whole separate conversation about, I think, which is the follow-up to how to ask a question, which is how to answer a question. You know, how to be a good witness. And of course, as lawyers, we have to prepare witnesses for trial, whether it's our clients or an expert witness. And teaching a witness how to be a good answerer of questions is a hugely important part of what we do too. But that, as I say, that is another conversation. So we'll see. We will see what happens starting this week. It'll be very exciting. And whatever happens, thank you, Shanin. This was so much fun. Thank you for coming in and doing the podcast with us. It's great to see you.
Thank you, Aaron. It's been great.